Hello. Good evening. We're going to get started now. My name's Kimberly George. I'm the director of the Guardianship Project here at the Vera Institute of Justice. Vera founded the Guardianship Project in partnership with the Office of Court Administration in 2004 in order to fill a gap in New York State's guardianship system and to develop a model approach for providing guardianship. Guardianship is, as a legal tool and as a support service, is complicated, it's nuanced, it's often necessary, sometimes unavoidable, and in need of scrutiny and limitations. In order to better understand the challenges facing New York State's guardianship system, the Guardianship Project, with generous support from the New York Community Trust, conducted a statewide research project on guardianship and all of its many facets. The findings of that research are what we're here to discuss tonight. As you can see from the thickness of this report, which I hope you guys all grabbed a copy of, there's a lot to talk about. And we have a lot to cover in the next hour and a half, or even less than that. So I'm briefly just going to tell you what the agenda for the night's going to be, and then we're going to just jump right into the program. So we're fortunate enough to have two very important people to the Guardianship Project here to give some opening remarks on why this is an important topic. And then we have our two external researchers who will give a brief presentation on the report findings. And then we have a panel of experts that will be moderated by another special guest here tonight, followed by Q&A. I will be introducing all of these speakers in turn. With the first one being, we have the Honorable Rory Lantzman, New York City Council Member to the 24th District in Queens. Councilmember Lantzman is the chair of the Committee on the Justice System and also a member of several other committees, including Finance, Land Use, Public Safety, and Criminal Justice. Councilmember Lantzman previously served 3 terms in the New York State Assembly. He received his Bachelor of Arts degree from Queens College and his law degree from Columbia Law School. The council member is a longstanding and very significant supporter of the Guardianship Project and an important advocate for justice for all New Yorkers, including the elderly and the poor. So thank you, council member, for being here.
It's my pleasure, and thank you for having me. I feel like today is Vera Day for me. I spent part of this morning with Herb Sturz, one of the founders of Vera. You probably are aware that there's an effort in the city to close Rikers Island, which is something that I'm very supportive of, and Herb has been a leader in that movement. I don't even know if that hearing, which started at 10 a.m., has finished yet. I bailed out about 2:30, but I did have the opportunity to hear him testify. I think he was in the same panel as Judge Jonathan Lippman, so it was quite a distinguished panel. This is the first time I think that I've been up here to Vera, and then I learned that you're about to move across the river, so I'm glad that I got a chance to see you all in your natural habitat. I was elected to the council in 2013. That was the same year that Bill de Blasio was elected mayor, and we had, I think, 35 new council members come into office. It was referred to and thought of as a progressive wave election. And at the time, progressives like myself would talk about the need to improve housing for New Yorkers and educational opportunities and take care of the elderly. And there was not a committee in the council that was responsible for looking at those issues through the lens of the legal system. But people realized very quickly, if you want to address the housing crisis, get people who are facing eviction lawyers. If you want to help families that are in distress, help women who are victims of domestic violence, help immigrants protect themselves against deportation, a part of the solution has to do with giving people legal representation. When Vera approached the council about funding the Guardianship Project, I think that we viewed it through that same lens, that here was an opportunity to do something that was politically progressive, to protect the most vulnerable in our society, the elderly, people with disabilities, people who are just very, very vulnerable, in a way that the legal system wasn't doing a very good job of protecting them. And seeing the work that you've done, and I can't say that I've read every line of the report, but I did read, through it. We're very, very pleased with this investment that the council and other organizations have made. I know that in the report there are ideas for how to expand the program, but I want to leave you with this. One thing that we learned in the council early on as we expanded legal services dramatically for tenants facing eviction, for people in guardianship situations, is it's not just the quantity of the legal services that you provide, and it's not even the legal services aspect of the services that you provide, but it's the wraparound services, the holistic approach. We now make sure, as to the extent that we have the resources available, that we're not just providing lawyers, we're providing, or lawyers who are going to represent someone in their criminal case or represent them in their eviction, but make sure that they have access to social workers, make sure that they have access to maybe lawyers who can solve other problems that are complementary to whatever it is that is the primary thing that got them into court or into the legal system that day. And I think that's the aspect of the guardianship project that we in the council are most excited about and most supportive of, viewing individuals in these very, very difficult situations as something more than just a case processing through the system, but trying to serve all the needs that they have, both because it's the right thing to do and that's how you best serve a human being, but also that's how you keep people out of the system to the maximum extent possible and let them lead their lives as fully and robustly as they can. So congratulations and thank you to Vera. Congratulations on your 1-year anniversary. Am I breaking news here? It's been a year. Give her a round of applause. I know with your very capable lobbyist, John Del Giorno, we'll be sitting down and talking about how we can take the successes that you've had with the project so far and with the council's maybe additional resources, build on those to even greater successes for the people that you serve. Thank you all very much.
Thank you so much, Council Member. You are our biggest supporter in the City Council, and not only does that allow us to serve more New Yorkers, it does exactly what you just said. It gets the other council members to pay attention and to support us as well. So thank you so much for that. Another very important supporter that we have is the New York Community Trust, who I mentioned earlier. Without them, this study would not have been possible. So we are thrilled to have Sean Moorhead here tonight, who is their Vice President for Grants and oversees their grant making of approximately $50 million a year, so not a tiny amount. Prior to her role as VP, she was the Trust Program Director for Human Justice and Education grant making. Sean received her BA from Columbia University and her JD from Stanford Law School. So Sean, thank you.
And none of that matters now. So someone once told me, of course people talk to you, Sean, you're like a dog with a pork chop around your neck, which is a pretty accurate description of a philanthropist. Don't quote me on that, please. The New York Community Trust helps charitable New Yorkers support causes that they care about now and for the long haul. And guardianship exists at the intersection of many of the causes that our donors care about, including older adults, those with disabilities, and somewhat uniquely, how our justice system serves those who can't afford counsel. Indeed, many of our grants are made to give voice to and empower those who otherwise do not have the means to influence public opinion or public systems. So you can imagine that when Vera came to us to talk about this particular project, looking for ways to give voice to those who are most likely to be written off as incapable. It was a very, very easy decision for us, particularly as our population ages and we are all hopefully living longer. Of course, the hard work was actually done by Vera and by the researchers that you'll hear from tonight, and they are who you are here to actually listen to. So with that, I am going to say thank you to Vera, thank you to the researchers for all the work that you have done, and thank you for the great work that I know many of you in this room do on behalf of the city that we all live in together. So with that,
thank you so much, and thank you to the New York Community Trust. It's now my pleasure to introduce our two researchers, but before I do that, they did want to know who is in the room. So I'm going to ask by show of hands, how many people in the room are currently serving as a judge? 2. How about any attorneys in the room? Okay, there's the winner. Anybody who serves as a guardian in the room, whether private or agency? So a lot of guardians as well. Anybody that works in social services in general? A lot. Anybody specific to the aging population? How about disabilities? And then just shout out. Did I miss anybody? Is there anybody want to tell us why they're here tonight that I didn't mention? Caregivers. Very good. Any other caregivers? Great. Thank you all. Okay. So you guys, you know who's in the room now, right? So I'm very pleased to introduce Dr. Pamela Teister, who is a professor and the director of the Center of Gerontology at Virginia Tech. She is the North American representative of the International Network for the Prevention of Elder Abuse. She is also a fellow of the Gerontology Society of America and the Association for Gerontology in Higher Education, and a recipient of many awards, including the Isabella Horton Grant Award for Guardianship and the Rosalie Wolf Award for Research on Elder Abuse. She is the former president of the National Committee for the Prevention of Elder Abuse. Dr. Teister has published over 125 scholarly articles and reports and is editor and author of 5 books. And joining Dr. Teister doing this study for us is Erica Wood, who is Assistant Director of the American Bar Association Commission on Law and Aging, where she has been working for almost 4 decades on issues of adult guardianship, health and financial decision-making, legal services delivery, and long-term care. Erica has participated in national studies on public guardianship and guardianship monitoring. She's played a role in convening national consensus conferences on guardianship and is currently directing a project for the Working Interdisciplinary Networks of Guardianship Stakeholders, also known as WINGS. Prior to 1980, Erica served as staff attorney at the National Council of Senior Citizens. She received her BA from the University of Michigan and JD from George Washington University. She too has received the Isabella Horton Grant Guardianship Award and was appointed by the governor to the Virginia Commonwealth Council on Aging. So thank you both for being here and presenting your findings. Come on up.
Okay, good. I like to be in the room where it happens. And I want to thank you very much for having us here on an important topic. In 2015, I got a call from a woman named Jackie Belageron. She was the then executive director here at the Guardianship Project, and she approached me about a study that she thought she wanted to do and that she wanted me to do it. How would I do that exactly? That evolved into the document that you have today. And when she talked to me about doing this, I told her if I had my wishes, I'd have the dream team to do the work. And one of the members of that dream team is Erica Wood. If you were doing anything on guardianship and you were going to talk about anything about how to make it good, it would be that woman. And the other person I'll talk about in just a little bit at the end of this presentation. An older woman was abused by her grandson, who was using all her money, and had taken over her house, forcing her to sleep in the living room without medical treatment. The landlord complained that the rent was not being paid. This would be a familiar scenario for many of you in the room who work on issues of guardianship, and particularly in this state. The purpose of the work that we aspired to do in this work, which actually spanned several years, was to recognize the important needs for supported decision-making whenever possible, and guardianship only as a last resort when with appropriate oversight and narrowly tailored to the needs of the protection of that individual. So our agenda in our presentation is to give you a little bit of an introduction to what we did, then to discuss who needs services from the work that we did, who serves as a guardian, what we found as New York court processes and barriers, and a discussion of the guardianship project assessment that we did. Our purpose was to try to understand and increase and improve guardianship and decision support services for a very challenging population. And this is a population of people who probably need these services more than any other population. They are a confounding population. People who we would call, and we don't like this term, unbefriended. Persons who are incapacitated and alone, with nobody and few resources. They are problematic to anybody who works in this capacity in the room. They confound attorneys, social workers, bioethicists, family and caregivers, agencies, and we still do not have great solutions for all of them. But sometimes guardianship is an appropriate decision mechanism, and oftentimes supported decision making is the appropriate way to go and to think about these issues. The objectives of our study were pretty large, and we thank the funder, the New York Community Trust, for funding this really set of large and difficult tasks. We were to document the need for guardianship and decision support services. We were to assess the current local and state ability to meet that need. We were to try to understand best practices of states providing comparable services. We were to assess the TGP model of guardianship to ascertain if it was an appropriate model for expansion in this state. And we were to try to understand barriers in court and guardianship processes and recommend some improvements that might be made. We were to look at, and I want to emphasize, both guardianship and decision support services, and we would be looking at Article 81 guardians. We analyzed previous research. We conducted the survey. We surveyed national contacts from earlier work that Erica and I and others had done to learn about their cutting edge practices. We examined current New York City and statewide guardianship practices, and we solicited stakeholder views about TGP and its replication, as well as membership of the TGP staff. We sent large amounts of surveys out to many of you New Yorkers. I learned, as a matter of fact, that when one sends an email to 500 people, that will be the largest number of email addresses one can do in one email at blast. I am pretty confident many of you in the room got an email message from Virginia Tech, and it would be me. And on some Friday weird afternoon, some of you responded, and I really appreciate it. We interviewed judges, we talked to court examiners, we interviewed people who had been here before, and we talked and we talked, and we did lots of phone calling. Why is this important? This is important for a number of reasons, because your populations, both for persons with disabilities who are younger and both for persons who are older, and whatever age category you want to put yourself in, it is coming to you. So your state has persons with disabilities. That population is growing larger. We used, by the way, my wonderful graduate student about 2 days ago after class did this particular graph for you from the BRFIS information from CDC. And then also we know newer information from the Center for Urban Futures that your population of older adults is increasing and has increased, oh my gosh, 26%. No big surprise to any gerontologist in the room that older adults are the fastest growing segment of the population, and the oldest old is the fastest set of those individuals. The population of people of all stripes are far more diverse than they have ever been, and yet what we also learned from the Center for Urban Future is the number of persons living in poverty has increased, and that begins to hit home to the population that Erica and I, with the wonderful help of folks at the Guardianship Project, helped us look at. So I'm going to stop here, and then you'll see me again, but I'm going to sit down for a minute, and then my colleague Erica Wood is going to take over on this particular part.
Great. First of all, can you all hear me? Can you all see me? Sometimes they say, you know, stand up, but hey, I am standing up. So anyway, I bring you greetings from the American Bar Association, where I've been working for many years and have been privileged to get kind of a bird's eye view of guardianship law and practice across states and over time. And I remember very, very well when Article 81 was passed back in 1992, and what a sense of hope and progress there was. I'm sure some of you in the room remember that as well. But you know, implementation is difficult, and it's not just difficult for New York, but New York, as well as every other state, has a marked gap between what it says in the statute and what goes on out there in the field in practice. And you know that, we all know that. New York and every other state has marked variations within the state, from region to region, court to court, and judge to judge, and attorney to attorney. Again, you know that. New York is different from all but about 5 or 6 other states in that it has 2, not 1, but 2 statutory schemes for adult guardianship for different populations. New York is different from all but 1 other state, that happens to be my own state of Virginia, in that it provides statutorily for review of the guardian of reports and accounts by somebody outside the court. So that's all to sort of give you a backdrop. Now we can sort of jump into the study itself. And interestingly, I wanted to say that when I read the 2018 report that came out of the Senate, New York Senate Guardianship Roundtable, I found that many of the issues and recommendations were similar. And that's really not a surprise because the issues they're there. So we're going to start with who needs guardianship and decision support services, and what services do they need. So we did find a compelling and urgent unmet need, that a need exists for guardianship and related support services for individuals in New York who are indigent, incapacitated, and have no one to serve. These are the neediest. These are the poor, and you know that. These are people who often have no natural supports, who may have multiple chronic conditions, including mental health problems, who may be at risk of or facing eviction. The stories we heard are your stories. You have the stories. Many of you told them to us, but they're your stories. And boy, are they stories. They can really knock you over sometimes. The stories we have, the data we don't have. And without data, it's very difficult to do judicial planning, training, monitoring. We're really working in the dark. Now, the Office of Court Administration has made a start on beginning to collect some guardianship data, and that's good, but there's a long way to go, and it's badly needed. So, supportive services. So, many of you know that oftentimes guardians put people in nursing homes because they need the care, and that's the most straightforward way to get care and easiest to arrange. Why is it easiest to arrange? Well, for one reason, because the supportive services are often just not there in the community. And so New York should provide comprehensive home and community-based services, including low-income housing for older adults. And so that would begin to change that dynamic and increase the quality of life and save the state money, because it's really much more expensive, as I'm sure most of you know, to go the nursing home route than the home and community-based care, which will save state dollars and is what people usually want. Save state dollars, give people the quality of life that they want. Social work skills. So obviously, guardianship is a legal proceeding, and many of the guardians who serve this target population of low fee, no fee cases are attorneys. But we found that what's really needed is an intricate mix of legal and sort of social services, social worky types of knowledge and support, and things like assistive technology, mental health resources, supportive housing, those types of things. And so New York should provide incentives so that not only attorneys, but social workers and nurses and occupational therapists will be able to contribute their skills as well. Less restrictive options. So we know that this target population needs services, but it's not always guardianship. What is needed here is a way to institutionalize and regularize screening for less restrictive options, such as advanced directives, powers of attorney, representative payee, combinations of services and supports, informal services and supports, informal supported decision-making, and formal supported decision-making agreements, so that people can, with the help and support they need, make their own decisions. And that will actually narrow the pool, the guardianship pool that the courts oversee, as well as providing more self-determination for individuals. So it's a win-win, as is restoration of rights. If termination of guardianship and restoration of rights can be made more accessible, and if there can be regular review of whether the guardianship continues to be necessary, that would both give people back their rights and winnow the court cases. Increased number of clerks and number of guardians. So whether the case ends up as guardianship or less restrictive options, we know by the figures that Pam showed you that the volume, just by the anticipated volume, there will be a need for more clerks to expedite these cases, to make sure that people do get their rights paid attention to monitor the cases as they move along. And there's a need for skilled guardians who are willing to serve this no fee, low fee population as a last resort, and with a goal of community living. That's a hard job. That's the job that many of you do. And compensation should reflect that. So who serves as guardian? And these are actually the chapters in the report. New York has 4 guardian of last resort schemes for this target population, and each is stretched thin. Together, they fall markedly short of addressing the need. So for those of you who know, the 4 guardianship of last resort schemes are adult protective services, the community guardian programs here in New York City, the Part 36 judicial appointments, and some scattered nonprofits throughout the state. But all of those channels are overwhelmed, and New York is different from some 29, and I just checked this as well as it can be checked, but Pam knows we need updated research on public guardianship. But when Pam and I did the research, we found, and when our colleague, who Pam will talk about later, we found 27, this was in 2008, 27 states had extrinsic official public guardianship programs. Since that time, two more states have enacted legislation. So I'm going to say it's 29, but the point is that New York doesn't have such a program. So I'm not going to run through all of these because of the time, but I did want to say a few words about adult protective services. Anybody from APS here? Okay, okay. So those that we talked to were very appreciative of the skills and the services of APS. APS in guardianship can potentially play 3 roles. So think about this. APS can and does, here in New York, petition if there is abuse, neglect, and exploitation. It's kind of a gateway to guardianship. Secondly, APS can serve as guardian. Now, they don't do this, according to those who talk to us and what we found. They don't do that here in New York City, but in some parts of the state, upstate, they do serve as guardian, and we found that to be an inherent conflict of interest. The third role would be to investigate and monitor possible abusive guardians, and we did not find APS doing that here in New York. It does happen in some other states, and that would provide an outside eye and help the court in monitoring. The community guardian programs here in New York City, and I'm sorry I'm going so fast, but that's the nature of the game, I guess, right now. The community guardian programs are critical, of course, but they're way understaffed and underfunded. And so additional resources along with a staff to client ratio would be helpful. I'm not going to, so I wanted to touch for a moment on evaluation and expansion of the pilots. As some of you may know, your legislature last year provided some minimal amount of funding, but hey, it's still good, for 2 pilot public guardianship programs, and those need to be evaluated and any modifications built in for possible expansion to other areas of the state. But that evaluation is, I think, very, very important. So New York court processes, maximizing self-determination on the one hand and expediting guardianship on the other hand were both prominent in the development of Article 81. And I'll just read this sentence because it's an important one. While it is important to comply with time deadlines set out in the law, it's also important to focus on the individual and support his or her rights. Well, that's a really difficult balance. How do you do that? So a recent study that was initiated by the Brookdale Center on Healthy Aging, and I see Jean Callahan sitting out there of Hunter College, with help from the VERA project and the Office of Court Administration. They did an in-depth file study of 14 counties and found unconscionable delays at every stage in the proceeding. So we tried to look at what is causing those delays and what are some of the possible solutions. And so read the report to find out more, but I will say that something that sort of jumps right out is kind of not exactly low-hanging fruit, but a little bit of low-hanging fruit is that there seemed to be quite a consensus on the need for development of uniform forms. You know, some states have uniform forms throughout the states. Many states don't. There's all kinds of varieties, but that if there was a uniform form throughout the state for the petition, for the order to show cause, for the initial report, and for the annual report, that could help to expedite cases, could help to expedite monitoring, and might even be helpful in data collection, as would ways to facilitate the filing of reports to enhance monitoring, such as, for example, opportunities for e-filing as it's happening in a number of other states. I'll just touch on one other thing, and that's the complaint resolution approaches down there at the bottom. Some states have developed forms and processes for guardianship complaints, guardian complaints, and that might be something that New York might want to look at, as some states have used mediation in a variety of ways in the guardianship process. So I'll stop there and turn it back to Pam, who's going to talk about the VERA Guardianship Project assessment.
So I told you I'd be back. One of the last of the objectives that we had was to evaluate the VERA, or the Guardianship Project, we ended up calling it TGP, is to see about its efficacy and its replication. In doing that, we talked to both, we sort of used a two-prong approach where we talked to all the staff, and if you were in the room, thank you very much, by phone. It was either by focus group or individually, as well as a number of stakeholders, including judges. We talked to several attorneys in the area. We talked to people who were doing mental health work, to try to understand from people who worked with the Guardianship Project what they thought of the program. The researcher and me must tell you that the interviews were an hour in duration, and we began to try to ask them what they thought of the program and solicited their opinions. We learned that these, not surprising, that TGP does exceptionally complex cases, and the quote would say to you that the complex cases are often low fee and no fee, and they are very difficult to resolve. And they take a particular amount of time to do that, to try to get things in place. And I was just speaking to one of the judges before as we were getting ready to begin this session, and I was asking him about how much time does that take to address this issue for this indigent, precious person? And he goes, forever. So I know that many of you would nod in the room. But we did have some recommendations for that. I want to talk just a moment about VERA too. Outstanding things that VERA does, and that I can tell you Dr. Teester has written with Ms. Wood in her book. They visit clients monthly. They don't have to do this. This is what they should be doing in best practices, and they do. The hallmark of their cases are that they try to help people stay in their homes. Erica talked about a criticism of guardians, and I have made it, of course, that guardians are too quick to put people into facilities. And VERA is or the Guardianship Project does not do that. They work very hard to keep people in their own homes and stop evictions, which we have already talked about somewhat. They are also, as we found from what we listened to in the colleagues, they are community builders. A person before you wrote a dissertation on public guardianship a long time ago. And I can tell you what I call what good guardians do. They're relationship architects. And it came to me that when I would see and hear about the things that happen at TGP, they are relationship architects, both in this state and others. And so I wanted to say that. They have produced and have done data and good work to say that the programs show a cost savings. And I can also vouch that programs can do that. I have done an amount of work on that in my own state of Virginia and in other states as well. And when it's done right and when it's done well, that is not just a pecuniary cost savings. That is a cost savings of human life. And that is preservation of human rights when it's done well. So just a little bit that we did learn that TGP could increase its ease of informational access by combining data systems. For those of you who like those sorts of things, I totally do. I understand that. Improving the funding model. So it was a hope that the guardianship program, the Guardianship Project would be able to spin off on its own. And it was built on a particular way of trying to having a case mix that would allow that to happen. And that has not happened yet, and that should happen. And we can talk more about that. So the funding should be increased for the program so that it can do its good work that it is doing. And it is a one-stop shopping, wonderful example of guardianship. They don't just have to go out to various people. They are in-house. And that is huge and important because it's efficient in that particular way. Outreach efforts should continue, and I talked about that. And then from many of the commentators that we talked to, none paid in my view, to say this, the thing that I think most compelling was give us more VERAs, but fund them. Give us more VERAs, but fund them. I'm at the end of our show here, but I want to thank all of those who completed our surveys and participated in the interviews. And I have a funny feeling a number of you in this very room actually did some survey, wrote me, helped me with things, helped me understand things, and Erica, and we are most appreciative. Many of you, I would have a shout out to Jean for sending us things. Alan Lawitz, who I was in Denver with not very long ago, provided us with really important information to help us understand guardianship in this particular state. Every state is different. I want to compliment Jackie Belageron. I'm glad she called in 2015. I want to thank my graduate students. If you've been a graduate student, your professor should thank you. So I want to thank these. And I'm shouting out to all of you. And then lastly, the person who would have been the dream team of 3, unfortunately got cancer and died. And we miss him every day because he would be up here telling me and asking me if I ever asked you if you could understand what I was saying to you, because he thought my Southern drawl was just way too much for anybody in New York to understand. And I even asked the Department of Social Services when I came up here to advise on some work a few years ago if they could understand me, and everybody looked quizzical. All right. Anyway, we miss him, but he was a New Yorker. Where I am, sometimes I called him a Yankee, but he is a New Yorker, and he really wanted, and very much when we did the national report on guardianship now some long time ago, Erica, that we really try to help make an explicit model of public guardianship done well, done right in New York. I want to be in the room where it happens. And I think you have the will to do this, to think wisely and well about what you have as a model, that you have pilots done. And that is a model done in the state of Erica and I have. We used a model to try to test out how to make this work for people who had no one for whom it was a last resort function. Thank you.
Thank you so much, Pam and Erica. You guys can have a seat up front. We're not done hearing from them. I can say that it was no small feat to sum up this thick report, and we were taking bets about how much minutes you would run over, and you guys really impressed me. That was amazing. We're now going to move to our moderated panel session so that we can ask these folks some questions. And so you guys can take a seat, and then I'm going to invite up and introduce our other panelists. We have the Honorable Judge Charles Troya. He was appointed as an acting justice of the Supreme Court in Richmond County, aka Staten Island, in 2013, where he presides over a guardianship part, a civil case management part, a civil mental hygiene part, and a specialized criminal mental health part. So he does a lot, to say the least. Judge Troya serves as chairman of the Guardianship Roundtable for the First and Second Departments and co-chair of the Guardianship Task Force for the Second Department. He received his Bachelor of Science degree from St. John's University and his JD from St. John's University School of Law. And next we have John Holt, who is Director of Legal Services and Policy at the Vera Institute Guardianship Project, where he has helped build our practice for nearly a decade. John is a presenter at trainings for lay and family guardians with the Guardianship Assistance Network. He is a member of the WINGS group here in New York City and has been appointed to the New York State Office of Court Administration's Guardianship Advisory Committee. John graduated from the University of Maryland, College Park with a history degree and received his JD from Brooklyn Law School. And then lastly, we are very pleased to have Michelle Chen, who recently did a comprehensive and critical analysis of guardianship, which we have copies of the article she wrote out front if you didn't get one coming in. She's here to moderate our panel. Michelle is contributing editor of Dissent Magazine and a contributing writer at The Nation, In These Times, and Truth Out. She is also a co-producer of Asia Pacific Forum podcast and Dissent Magazine's Belabored podcast, and she teaches history at the City University of New York. So please come on up and let's get started.
There's another mic here. Is this yours, mic? You need a mic. Yes, you need your dog collar.
Everybody needs to turn it on. I think I turned yours on. Yep, if it lights up green, you're good.
Okay. Playing barroom trivia or something. We're all set up here on really tall chairs. Can you hear me? Okay. Well, so nice to be with a panel of such people of such expertise, because I came into this topic just as a reporter, but I'd been reporting on elder care issues for a long time, but I had never really known very much about guardianship, and I realized it's such a sort of hidden part of a really sort of broad safety net. It's often neglected, so I'm glad we're having this conversation. I guess my first question is for Judge Troya, or Acting Justice Troya. Why don't you start with sort of the brass tacks and talk about what Article 81 is, and how this form of guardianship was sort of crafted in terms of the law with a specific purpose in mind?
Well, I think one of the greatest aspects of Article 81 is that it's flexible. It refers to individuals that suffer from incapacities that need assistance. So it changed from making a declaration that someone is incompetent and not able to make any decisions to incapacity, which in my opinion is a much broader, much more general term, and allows us under New York system of New York's legislation using Article 81, allows us greater flexibility. The term incapacity doesn't have the stigma that the word incompetent has. And it also takes into consideration the fact that an individual may suffer from an incapacity that prevents them from handling one aspect of their life, but that does not necessarily mean that they cannot handle other aspects of their lives. So Article 81 within New York State does give us the flexibility of allowing people to continue to live independently. We do not take complete control of someone's life, and that we only limit the powers that we give individuals, the control that we take away from a person, to the utmost minimum that we can do. Yes, there are a number of people that do require full guardians to make all decisions for them. But the one thing that Article 81 recognizes, which I'm truly appreciative of, is the fact that we do have the flexibility to limit taking over someone's life to just providing them with the assistance that they need. And that's why I personally think Article 81 should be a model of legislation for dealing with individuals that need assistance.
As a judge, how well do you think the court system currently does in terms of fulfilling the goals and the mission behind that law?
Well, first of all, I was very happy to find out that the Office of Court Administration does play a vital role in the Guardianship Project and in VERA. I think that it's wonderful that the Office of Court Administration was able, especially in these times of budgetary constraints, to actually provide financial assistance and financial backing to VERA. I do wish that this would become on greater of a state level, where we would have absolutely more funding, where programs such as the Guardianship Project could be expanded statewide, where they would be able to take on more cases. I'm not necessarily saying that the Guardianship Project itself should expand statewide, but that the model that they use should be used statewide. And I do think that the fact that the Office of Court Administration has taken the risk here in funding the Guardianship Project just goes to show how committed the court system is. I think that the judges that preside in Article 81 parts are selected because it is a different area of law. It's not just based on what the law is, but it's based on a human compassion and understanding of the individuals. It can be sometimes a very frustrating area to work in, because you take 2 steps forward and then you end up getting thrown 5 steps back because of the individual that you're dealing with, not because it's intentional, but just because of the circumstances. So I do think that, at least within New York State, the judges that I've seen that preside over these parts are truly committed to them. And I have contact with a majority of the judges within the city of New York and the upstate counties and Long Island, and all of them are truly committed. And I think that Article 81 does give them a great deal of assistance. yes, there are some issues and some problems out there. And quite frankly, the problems are all related to funding, which is, I think, one of the major themes that you'll see throughout this report that the Guardianship Project has produced. Funding is vital. Dealing with someone that has an incapacity it's very complex. It's not as simple as settling or resolving a civil case or taking a plea in a criminal case. It's something that goes on generally for the lifetime of the person. And in order to provide the proper services, we do need greater funding, and we do need, in my opinion, more guardianship services based on the model of the Guardianship Project, which is the holistic approach. It's social workers, it's lawyers, it's nurses. Quite frankly, we try and push to get as many nurses on our approved panel as possible, because it's so much easier to turn to a medical professional and say, give us your opinion. Is someone being abused? Are they receiving the proper medical care? And quite frankly, a lot of times in our cases, initially we'll turn around and I'll ask a nurse to step in and to go out and review the person's medical history, because unfortunately a lot of the older population, if they don't have someone pushing them to get medical services, they don't. So truly, I think that within the state of New York, I think that the court system is doing, yes, there are things that can be worked on, processing our paperwork a little bit quicker. Absolutely, there's no question about that. Getting the orders out there. It does involve a lot of paperwork. I think a lot of the paperwork is in fact necessary, because we do need to have the oversight and the checks over individuals that are serving as guardians. But yes, I think we could do it a little bit quicker. We could streamline it and make it a little bit easier.
This is a question for Erica Wood. I mean, as you noted in your presentation, guardianship is not the only form of intervention or social support that can be used in the court context, and also, when dealing with really complex cases of indigent, aging people. Do you think guardianship is applied appropriately in many of these cases, and what happens when, or I guess, how well do you think it fulfills the goal of always going for the least restrictive option when these cases go to the court?
Right. So I don't know how many of you have had a chance to read Michelle's Truth Out article. And I guess there are copies out there, but it does a good job of showing how much control of one's life means to a person, how guardianship, there's a loss of fundamental rights, but really there's a loss of personhood, of self, of control, of choice. And a loss of dignity. And dignity, yes, a loss of dignity, and how very, very important those things are to a person's life. That really fundamental. That is their life. And so guardianship is a really drastic measure that has to be a last resort after less restrictive options, as I said earlier, have been examined. And again, and I'll repeat, I know that many of you know what we mean by less restrictive options, but powers of attorney, representative payee, advance directive, and various services and supports. Supported decision-making has really shaken up the guardianship world and made us think in new ways, and that's a good thing. And so you could have an informal supported decision-making arrangement where a person would rely on trusted friends that he or she chose to help him or her, to help the person make their own decision, so that that personhood and control would remain. Article 81, as Judge Troy has said, puts a very big emphasis on, I think the words used in Article 81 are the least restrictive form of intervention consistent with the needs. And I know that New Yorkers might not be interested in the uniform law, but you should take a look at it. It has some very good things in it. So please do look at it, and one of the good things is that the judge must make a specific finding with clear and convincing evidence that less restrictive options, including decision supports and supported decision making, will not suffice to meet the needs in that particular case before making an order. You know, and I know all of you know this, that guardianship petitions are not always brought because of a need for protection and a loss of capacity. It could be family dynamics, family feuds, so-called premature probate, a need for housing, as we've talked about, many other reasons. And so sometimes guardianship is seen as a panacea, a silver bullet, a quick fix. You know, guardianship will fix it, but it can't always be that solution. And so what's needed, I think, is a routinized, institutionalized way to do that screening every time. The ABA Commission on Law and Aging with other entities of the ABA put together this practical tool, which is meant to make attorneys and it's for attorneys, but anyone using it just stop and run through these steps. The practical is an acronym for 9 steps to run through in every case to make sure that you have that, that you really do have the least restrictive option, but New York should really institutionalize its own form, I think.
Just to bounce off of that, I know that in the INVERA's sort of pilot project, there were a number of cases that began in guardianship and then were later, the people realized that they no longer needed guardianship, and that was a scenario that you know, you do encounter. How does that work exactly under sort of the rubric of this law when you have, do you have constant monitoring to see if guardianship is still in fact needed for this person?
Well, termination of guardianship and restoration of rights might occur if conditions have changed, if new evidence is uncovered, or if the person has additional supports. And so every state has a procedure for ending guardianship and restoring rights. The problem is, and actually Pam and I did a study on that too, that it's not used much. It's like a needle in a haystack. A needle in a haystack. If it could be easier to use, and there are ways to make it easier to use, if people could be informed upfront and earlier of their right to restoration, and if, as you said, Michelle, there's a routinized way to continually check as to whether the guardianship is still needed, there are ways to make sure that it's used more.
And we'll go to John Holt. And I guess you can speak to, well, you know, the project that we are talking about today. What specific need did it emerge to fill? And I guess I know that, you know, the project struggles with issues of capacity, but do you see it, what do you think is the best way for the type of work that you have done successfully to ultimately scale up?
Sure. So I think there's certainly been an evolution of the need that the project's filled since its inception. I mean, the impetus for it was certainly some high-profile cases of exploitation and abuse of guardians, and a recognition that there was at least a gap or a disconnect for a very much needed population of people who had high complexity needs and didn't have assets that would basically support a private guardian, a professional guardian, from taking those cases. And I think there's a real problem with that model in general of having, you know, the assets of a person who is subject to guardianship be a driver for who is going to provide services, how they're going to provide services, and how well they're going to do that. And so we started taking cases where mostly people who were low income, low asset, where there really wasn't a real ability for other guardians to really take these cases. As we've been serving cases over the last 15 or so years, what we've seen is that the model, and I should say very clearly what the model does is marry the interdisciplinary teams that we have, lawyers, case managers, social workers, finance associates, who all work very closely at every stage of the guardianship from the time that we accept a case on through discharge, whether that be because of the person passing away or because we've been able to terminate the guardianship and restore their rights to them. And as we served cases during that time, what we realized is that this model really does a very good job, yes, taking cases where there is not an incentive for people to take it because of the monetary disincentives of taking it from a professional standpoint, but also cases where there's just such complexity in the issues that are being faced that any guardian would have a difficult time serving them by themselves. You have a situation where you have somebody who has complex legal needs, ongoing issues with home care, healthcare decisions. This could be an everyday job. There are clients that we speak to on a daily basis. And if you have somebody who's trying to make this part of their practice as a private attorney, and to do this, it's very difficult to give the kind of attention that's needed if you want to fulfill the goals that are present in Article 81, to do this in a way that maximizes the autonomy of the person under guardianship and has them be a voice in all of the decision making throughout. So, if you want to make a decision every day and you need to have the input of the incapacitated person, the person who's under guardianship, how do you accomplish that if you can't go out and see them, or you can't talk to them, or you have other work that you're doing, or you're in court? And so, and on top of that, if those needs are so varied that one moment you're talking about something that's usually within the purview of a social worker and their training, and the next minute you're trying to give some sort of legal advice or to figure out how to accomplish something in housing court or some other litigation, it can be very difficult to transition. And so we've seen that the model really does a very good job of serving these high complexity cases and providing a high quality of services. And so as we look forward, how we see the replication of the model, I think to our mind, this model serves very well in its current capacity in taking these high need cases, making sure that they're well serviced, making sure that the voice of the person who's subject to guardianship is a key component in providing those services, while also looking at ways that we can modify the way that we're providing our services so that we can do it in a way that addresses needs for people who are not so complex. Part of the problem with having an attorney and a case manager and a finance associate assigned to these cases is that it's expensive to provide it in that way. And so we're trying to find ways to be more efficient, to use the lessons of the model and ways to identify that we could use the model while not maybe staffed in the same way to provide that level of services for people, regardless of what the complexity is. And I think it's important to note too that these cases are never static. What you get in a case as far as case complexity on day one is going to differ greatly from what it is in year 2 or 3, and it's going to differ again in year 4 and 5, and that may fluctuate throughout the course of the guardianship depending on what the needs of the person are. So you need something that's adaptive and responsive to those changes in the needs of the person.
When you were constructing this model, were you looking at other those extrinsic offices of public guardianship that exist in other states, or were you just sort of starting from scratch and seeing what services made sense in terms of assembling the service array that you are currently providing? And I guess maybe you can compare this with other states that do have like an official office of the public guardian.
Sure. So I've been at the Guardianship Project for a long time. I wasn't there at the inception, so but I do have some understanding of what was being looked at. And I don't think there was a close analog to guardianship services per se, but there are some other. We certainly looked at other public guardianship systems in New Jersey and other places, and to try and see also how their social service organizations were using this marriage of legal services to try and figure out what would be a good fit. And I think part of the problem when you look at something like using the guardianship model for, say, a public guardian who's the guardian of last resort is, again, one of the things that makes us able to service these cases in the way that we do is being able to select the cases that we serve, to be able to keep our caseloads manageable so that we have a low ratio of staff to clients and that we're able to provide the personalized services. And I think it can be difficult to think about what that model would be if you're the guardian of last resort who is required statutorily to take all of the cases that come to you. How adaptable can you be? You can't just staff up in a moment and suddenly serve an influx of cases. So I think there are a lot of lessons that can be learned for any guardianship agency or anyone who's providing services about how to use some of the things that we have kind of perfected and done in providing services to better implement that. But I think that necessarily taking the model and just saying this is the right model for public guardianship, may be a step too far without really looking at the pros and cons of that.
And finally, Dr. Keister, I guess when I first started looking into guardianship, just researching it, I came across all these horrible news stories about abuse cases involving guardians. As we all know, like in the New Yorker and all these other. The issues that we're discussing tonight, how related are those to sort of the broader dilemmas facing the entire sort of infrastructure of the way guardianship works, even in, fee cases, which is where you see a lot of the abuse happen. And I guess like as someone who's been sort of studying this field for a long time, what are some of the broader lessons about guardianship writ large that we can pull out of this example?
Um, it's a good question. I have actually, most of my academic life, which is getting longer all the time, has been actually to look almost equally at guardianship as well as elder abuse. And so for those of you in APS in the room, if you've escaped a survey from me, I'll be with you too. There are pockets of places in the country, and I am sure that you could only Google them to find, where there has been abuse by guardians. I can tell you that we see the more sensational cases. I would expect that I have done studies of where they exist in the country. If you track these things, you would have seen some notably in Nevada, recently in Florida. You had some in your own state at one particular time, which was the impetus for your fixing an issue. Chicago was notorious at one particular time. California has been. It is not confined to one system of guardianship or one type of guardian. By the way, any APS person in this room would tell you that the person who abuses and exploits and neglects the most are family members. And so I just want to say that there's an equal opportunity here for any kind of person who is a guardian to do a bad job. But I also want to say that of the people who serve as guardians and of the systems I have studied, and it's been many because I've done national studies of guardians and I've gone to many of them, that the majority of guardians will do a really wonderful job if the orders are created in a way that they are tailored to the needs of the individual, that we can restore rights. My writing and Erica's would say that every good guardian, John, you're one of them, would work him or herself out of a job. That would be my goal for what a guardian would do. And that would put restoration front and center in doing that. So there are pockets of that. I'm actually doing a study, just to let you know, I'm actually doing a study right now in sites in 6 counties and cities across the country of the abuse by guardians, by powers of attorney, and by representative payees. Don't have the data on that yet, but I will in about a year. And I can tell you a little bit more about that. Who leads the pack right now, just to like cut to the chase? Powers of attorney. Okay, so that'll be news. So I'm just saying, abuse of systems occurs everywhere. The correct panacea for that will be data, so we know about how many guardians there might be somewhere. Outcomes of the guardianship that we have. Did you make somebody's life better? At least did you maintain what they did? These would be things guardians ought to do. Your records or your forms could be uniform, so somebody might be able to enter those and understand what they meant. And that's not just New York, that's everywhere. But you have a great opportunity to fix that. And then better monitoring and oversight. It's critical that the start of a program is a wonderful thing, but the implementation of it and the following of it and the monitoring of it is absolutely as important as is the establishment of it. And so to cut to the chase, Michelle, monitoring is really absolutely critical. It's not sexy, but it's really critical.
Mm-hmm. I was just going to ask, I mean, beyond the sort of the nightmare stories that we often hear about, I mean, if you had one sort of reform that you would like to see implemented sort of on a large scale in terms of the way guardianship works, something that could actually sort of, I mean, to be honest, I spoke with disability advocates who are sort of categorically opposed to the idea of guardianship, right? From an ethical standpoint. So I guess from an ethical standpoint, what is one reform that you would like to see implemented in guardianship systems sort of across the country that could be sort of, a safeguard against not just the most egregious violations, but just, the encroachments on personal liberty and other things like that we, sort of want to hold as kind of just a general standard of care in these cases. I guess, yeah. If you had one reform. Right.
Okay, as a bioethicist, by the way, data. Have data. And that will deal with the monitoring function. Would you like to know in one state how many people are under guardianship and who they are? We don't know this. It's unconscionable. You know when your Amazon box is coming, He'll take a picture of it for you. So I think and I guess by saying that, the form follows function here, because you can't have information about it if you don't have the reporting and the oversight in place, because that's what would feed it into it. So if we will know that, I think that's really critical.
I guess we can go to question.
Go.
Yeah,
Sure.
the abuses that you mentioned, power of attorney, that would.
1 second. Oh, yeah.
Hi, I'm John Leventhal,
Hello.
and I did preside over guardianship part for 7 years and did elder abuse and domestic violence at the same time. But the abuses that you talked about, power of attorney, if you have a power of attorney and advanced directives like a healthcare proxy, that would be outside of a guardianship in New York in most cases. So that a guardianship really wouldn't help that. And in New York, we have safeguards because an attorney is assigned to the alleged incapacitated person and also a court evaluator. And if they don't want to have a guardian, if they have some kind of competency or they want to limit, their attorney will fight for them. There are some people who really need needs of person and property that you're never going to get it outside of a guardian. They may really, and they may have no funds. And before Vera came, which is very important, I used to talk to the lawyers in the room who were experts, and they would come and give, it was a collaborative way to do something. So there are a lot of safeguards in New York, and I don't think you could eliminate guardianships for all people, but if people have advanced directives, yes, there can be abuses by relatives, but that's outside the guardianship. So I just want to point that out.
We have time for about 2 more. You're first.
I won't need the mic.
Oh, if you could speak it to the mic for the live stream.
All right. I am a victim of one of these abusive guardianships. All right. From the initial hearing, my mother was assigned a lawyer whose specialty was collections. She was not allowed to get her own lawyer. All right. When I did try to find other lawyers, as soon as they found out it was a guardianship case, they said, it's going to be assigned. That's it. When I tried to find a lawyer for myself as her caregiver, there was no agency that would do it. I had a full power of attorney, but was not allowed to use any of her funds to find a lawyer for myself or for her. During the course of that hearing, I requested to represent myself pro se. I was denied that. I was told I would be able to speak afterwards. There were allegations made about me in the hearing that I went to refute. The judge said, we will not go back to former things or past things. We will only discuss future. All right. During that hearing, my sister had requested the guardianship. She had seen my mother twice a year for the previous 5 years. She had me investigated by DSS for financial impropriety. That came back as unfounded. There was never any impropriety. There was never any matter of wrongdoing. I was the guardian that was assigned. At the very end of the hearing, the judge noticed, and I put that in quotes, that there was a commercial piece of property that I spent my entire life paying for. It was in my mother's name, and because I didn't want to, basically, I wanted her to retain her dignity, to make sure that she had her own sense of self, that the things that she thought she can control, that she still felt she was in control. So I didn't do anything with the power of attorney to rob my mother. I never took $1 from my mother, except the last year and a half for food, groceries, medication, and for diapers. That was the only money I ever took from her, and it averaged $100 a week. That was disputed. When the court evaluator came through, he tried to say, your son's writing checks to himself. If he had asked me, I would have told him I'd write $100 a week for groceries, for medications, for whatever her needs are. The bank requires me to write the check to myself because they won't write it for cash. Okay, but he tried to push that as that I was taking it for my own purposes. For 5 years before that, she didn't pay for food. She didn't pay for groceries. I cared for her, made sure she took her medications, made sure her doctor's appointments were done. They still appointed a guardian. And the main reason they appointed a guardian was because of that commercial property. And they turned around. The guardian that was appointed was a real estate expert. At one point, he assaulted me in my house. He was beyond the 90-day limit, that term that was required by law for visitation. He snatched papers from me. He threatened my mother to throw her into a nursing home. He then made an appointment to put her into for an evaluation on a day that she was diagnosed with a UTI and a blood pressure reading of 70/60, and he still had police there to make sure he took her. I was not allowed to accompany her. And he then cut off funds for food, medication, for diapers, for groceries, for everything for 1 year. I survived on rolling over a charge card and borrowing money from my friends. I was in there as a full-time caregiver. And when I went to DSS said, tell the judge. I said, I wrote 7 letters to the judge. She said, well, we can't do anything about the guardian. But yeah, well, I will get to that in 1 second. She said, we can't do anything about the guardian. But if you fail to provide food, medication, etc., for your mother, you can be charged with abuse and neglect. I was conscripted to 24/7 care without any form of compensation and had no input. I was a chattel. Is this the type of thing? Is this the type of thing that you're going to allow? You're going to allow with guardianship?
Well, I'll try and field this the best I can. So all I can tell you is that your circumstance, we're not aware of the matter. That's something that may have happened in a particular case that maybe none of us were present there. None of us are really
approval of the judge.
Okay.
And
Well,
in full knowledge.
okay, but so what I'm trying to say is that, and I think what our panelists have in fact recognized is that there are some abuses. There are abuses by guardians, there are abuses by non-guardians. We have checks in place within the court system when a guardian is appointed. It's very difficult to comment, sir, on particular facts when none of us were present there. I mean, that's all I can tell you, sir.
Arthur Diamond,
Thank you.
in that roundtable discussion, said that we have too many indigent people coming into guardianship. We need rich people to basically make sure the lawyers are paid. And not one person in that roundtable stood up and said, that is unacceptable.
Okay. I'm sorry, sir. I don't know what roundtable you're referring to.
Thank you. Yes, we've got about
January 19, 2018. Look it up.
Yeah, we've got maybe about 2 minutes left if anybody has an actual question and not a comment. One quick question? All right, thank you.
I just want to thank you all for the presentation today. It's been good. Just a question for the judge. Do you have any ideas about what we can do? I work at a not-for-profit office in Buffalo, New York. We serve as guardian for about 100 in Buffalo, New York. Yep. And we serve as guardian for about 100 people, very similar to Vera here, and social workers, benefits coordinators, et cetera. I worry sometimes, what's really tough is I will give a bank or somebody a Supreme Court justice's order, and they look at me like I have 3 heads. And I'm wondering, you know, us in this room know that we have the rules of guardianship and we get a commission, but is there a way that maybe we can think about a better way to educate the general public as well as banks, financial institutions? There's times when you send a court order and the commission to the bank and they think that the person who's listed as the petitioner is the guardian. And it's one of these things where what can we do to educate folks more? Because, and same thing with federal agencies, they don't seem to care too much about state Supreme Court justices' orders. So just any ideas about that? No, no dishonor, no disrespect, Your Honor, but it's one of those things.
You know, the interesting thing is that the problems that I see that we have with dealing with banks are the larger banks, which is what really surprises me because those are the banks that have the
huge legal department and have individuals they can go to help. The small local banks are the ones that really don't give us a hard time, that are very accommodating, that will actually get on the phone and call my office and say, we have this order. And they will tell us what question they have about it. That's the interesting thing. There are large banks that we can't even get in touch with their legal department. I'm not going to mention the one particular bank.
I think I know which one you're talking about.
But, you know, I have a judge sitting in this room here who actually said to me, the way you do it is if they're not going to contact us, then we're going to have to subpoena them and bring them in. And then eventually the legal department contacts you.
We have had some luck actually making complaints through the banking department through the state and making a CFPB complaint. And some within 3 days they want to talk to us.
My recommendation is you need outreach by the Bar Association because the banks are looking to attract the business of the lawyer. And bar associations that can draw them in so that they can be educated on what guardianship is all about.
All right, one last question. I'll come to this side of the room. And then after that, you can feel free to just email any one of us with your question, and we will make sure the entire panel receives it.
Hello, thanks so much for putting this together. So I have a question about how do we think about, how do we bring, when we're trying to bring stakeholders into the room, whether at events like this or in various decision-making processes or the oversight function of various programs, how do we effectively and meaningfully include people who've experienced guardianship either presently or formerly, and not just people who are in the caregiver role, but people that were themselves put within a guardianship role? Because I think that I wonder if you could speak to sort of the structural issue, because if a guardianship, by definition, is labeling a person as partially incompetent, I think that can create complicated dynamics, both like logistically in terms of how people are categorized, and then also how those people are perceived in sort of different policy discussions. And that question is just informed by my experience in different people who've been in these situations or in policy discussions around issues of coercion and treatment. Is that's often a struggle. So that's just a question that I have.
I'll take a go at that. Thank you for asking that important question. And I'm familiar with that issue because one of the things that we've been working on at the American Bar Association is bringing stakeholders together in the state in what we call working interdisciplinary networks of guardianship stakeholders, or WINGs. And the issue always comes up about making sure to include self-advocates, including people subject to guardianship, as well as family guardians, because they too get left out sometime. And I think it takes a lot of thought. It takes a lot of planning in advance. But what I have seen that's been successful is to have individuals who have been subject to guardianship and have had their rights restored. And so that they've had the experience of losing those rights, and then they have had the experience of being restored. And that's not quite the same, but at least it gets you somewhere. And I think that your question, just keeping to the front of our minds your question, is an important thing.
Just a question on that.
Oh, may I finish just a second? I'd like to respond more. Hang on just a minute. I want to say, I think I'm glad you asked that question too. And I want to say, I'm not of the ABA, but as a researcher, we tried a lot to try to get people who were under guardianship in our studies. And I think we were successful in our national study. We didn't always get a lot. And sometimes the agencies that we even interviewed, they wouldn't allow us to talk to them, but some of them did. And it really, they were able to talk about their experiences under guardianship and of being a person under guardianship presently. And of course, I think they were often more high functioning of those individuals, but we were able to get the programs, and I'm talking about public programs, so these would be the last resort function ones. We have had them in a number of the studies that we have, and I can tell you, they've made every one of them richer. So I think you just have to keep, I think for that particular voice, you have to push it. I mean, but I think it's critical.
I think language is important too, and the way that we speak, whether it's using terms that come from Article 81, and I think obviously incapacitated is probably a less pejorative term than incompetent, but it still carries a certain stigma to it. And we have two people who may be similarly situated under the law insofar as they've been adjudicated incapacitated, but speaks nothing to their personhood and how different their experiences are under guardianship and how much ability they have to be a participant in their care. And so when we educate people, when we talk about guardianship, we need to make sure that we're highlighting just how different, and the language in the law is good. Narrowly tailored is important, but people need to understand that when you say somebody is incapacitated under the law, it doesn't mean that they can't speak with you, that they can't express their viewpoint, that they can't be a participant. Because when people hear that, they don't want to talk to them. They don't think that there's something to be gained from hearing from that person, and certainly need to change the discussion around that so that people understand that that's not what guardianship means. That's not what incapacitated means. It's a legal term only.
Well, unfortunately, we're over time, and I do want to, let everybody out of here at the right time. I'm thrilled that there are so many questions. I'm sorry that we don't have the time to entertain them all. I do encourage everybody that did not get their question answered tonight to email them to us, and we can have the whole panel weigh in and get back to you. I am enthused by the interest in this really complicated conversation, and we will be thinking about ways to continue the conversation. And given that it seems like a lot of people in the room are interested in talking more, we will think about ways that we might be able to have future, if not in person, maybe virtual, regular conversations, so that we can keep the conversation going. I know that we at the Vera Institute and the Guardianship Project are committed to continuing this work. This research study was just a start. The practice and the model that we've built is a model, but it only serves the people that we're serving. We want to have a larger impact with all of the lessons that we've learned and start doing some of the system-wide changes that have been mentioned here. There is a lot that can be done and needs to be done. So I first and foremost want to thank all of you for coming out on a Thursday night, the same day that public school started in New York City. So it's been a challenging week for me, I can say, and I'm sure a lot of you. And of course, I want to thank our panelists and our moderator, our researchers, the judge, John, Michelle. Thank you so much. And have a wonderful evening.